My name is Roland. I'm with the Show Me Institute, and today we're going to talk a little bit about eminent domain. Eminent domain, of course, is a topic with which people in the St. Louis area are very familiar because there have been a number of projects that used eminent domain in recent years. What I want to talk about now is one of the unique elements of Missouri law as it regards eminent domain. If you'll remember, a few years back, there was a United States Supreme Court case called Kelo versus New London. And in that case, Suzette Kelo and her neighbors in the Fort Trumbull neighborhood of New London, Connecticut, were having their properties, their homes, and businesses condemned by the city in an effort to replace them with luxury condominiums, high-end retail shopping, and the city tried to justify its taking of their property by saying this is going to be for economic development. This is to increase the tax receipts for the city. And so the question that the United States Supreme Court had to answer in that case is, can we consider economic development a public use under the United States Constitution? Unfortunately, the United States Supreme Court said in a 5-4 sharply divided opinion that yes, in fact, economic development could be considered a public use. This was kind of the culmination of a long string of cases for the U.S. Supreme Court. Going back to the mid-1950s, there was a case called the Berman case where the Supreme Court took the Fifth Amendment, which specifically says that if property is going to be taken from a citizen, it has to be taken for a public use. And the court said, well, we know that the words in the text say public use, but what we really think this means is a public purpose. And so, whereas previously public use had been restricted to things like courthouses or roads, things where the property that was taken was going to be owned and accessible by the public. Now, all of a sudden, it meant that you could take what belonged to one person and give it to somebody else if you thought that it would have a public benefit in the new person's hands. And public benefit was defined very broadly. So in the Kelo case, again, the question is it okay to take what belongs to one private citizen and give it over to some other private citizens simply because the city thinks it'll make more tax revenue by doing this? In Missouri, there are, well, real quick, before I get to Missouri, I'll say that the court in deciding the Kelo case essentially said it's up to the states to define the limits of eminent domain abuse. Each state has its unique constitution. Each state has limitations and definitions related to the use of eminent domain authority. And so they said basically the states can put harsher limits on the use of eminent domain if they want to, but the federal constitution doesn't require it. So property rights advocates in Missouri needed to start looking at the Missouri Constitution to see what their document says to protect property rights here. And actually, the text of the Missouri Constitution is great. Missouri has more provisions restricting eminent domain than any other state in the nation. They specifically say that you cannot take private property to give it over for a private use. That's a stricter requirement than you have in the United States Constitution. They also say that if a city or a government agency says that something is going to be for a public use, then it's up to the courts to decide whether the use is really public. One of the things that happens in other states is if the city says that something is for a public use, the courts will defer to the city's judgment. This is a terrible idea because the elected officials who are making this determination stand to benefit from calling something a public use. And so it's basically letting them be the judge in their own case. But Missouri's Constitution doesn't permit that. If a Missouri city says this is going to be for public use, the courts are required to exercise independent judgment as to whether that really is the case. So how do we get to the situation where Missouri has some of the worst abuses of eminent domain in the entire country? You know, if you've got such strong constitutional language, you would figure that, you know, the problem would resolve itself. Well, this is the story. Back into the 19th century, when Missouri was founded as a state, when the first constitutions were written, there really was a clear understanding about the limits to the use of eminent domain. I've got a quote that I'd like to read for you from an early Missouri Supreme Court case. It says, "Land can be taken for the purpose of being used by the public as a road, a canal, a bridge, or a mill, for a basin or a wharf, where the necessity exists that the public should have such use of it." So you see, they're linking very strongly to this idea of a public use rather than a public benefit. But it is not such use of it as is intended by the Constitution when land is taken for the purposes of revenue. Nor is it taken for public use, nor does the exigency exist for taking it when it is already applied exactly in the way it is proposed to use when it is taken. So they're saying you can't use eminent domain for economic development. This decision from the Missouri Supreme Court in 1851 is directly to the contrary of what the United States Supreme Court said just a couple of years ago in Kelo. So you'd think, well, you know, again, you've got a good interpretation of the Supreme Court, a good interpretation from the Supreme Court of the Missouri Constitution. What happened? Well, the problem is that the powers of government got confused. There are a handful of different powers that government has. Among them, taxation, we're all well familiar with, just having passed tax day. Eminent domain, which of course is what we're talking about today, and the police power, which is another common power of government, which is where the government uses its authority to prevent or end threats to the health, safety, or welfare of the community. What people lost sight of about the turn of the century, the turn of the 19th into the 20th century, was this distinction between taking property because it's useful and trying to prevent harms. If you'll remember, about the time of the Great Depression, the cities were growing because you had a strong influx of people from agricultural areas looking for work, and you had the rise of what were considered slum and blighted areas. These are just pockets of town, parts of town, where a whole bunch of poor people were living. And frequently, the conditions there would be pretty bad. You'd have large numbers of people living in very small dwelling places. You'd have crime happening in these areas. The landlords wouldn't be receiving enough money in rent to keep up the properties, and so they'd fall into disrepair, and it was very dangerous. And so public officials, this is the era of progressivism that we're talking about, public officials said, well, we don't want people living in these kinds of conditions. So what we're going to do is we're going to take away these properties from their owners, and we're going to build these brand spanking new public housing developments in their place. Well, there was a problem. The reason that they wanted to take away these buildings was because it was a health, safety, and welfare concern. But that's a police power issue. And the police power does not give you the authority to take what belongs to somebody else. So they have the power, if they needed to go in and destroy a dilapidated building. Or they could require you to mow a lawn that had grown up too high so that rodents and vermin were out there. Those were efforts that the cities were allowed to engage in, but you couldn't take title to it. And so what the cities were concerned about is, well, if the title remains with these slumlords, then that means that they can just let the properties fall into disrepair again after we've gone in and cleaned them up. And so the solution was to pass a law saying that as an exercise of the police power to remediate blight, you could go in, tear down these buildings, and take title from the owner, so that the city would then build its public housing developments. Well, The first law that was passed to this effect was in 1939, and there were a lot of concerns about whether it was really constitutional or not. No one challenged it, so it didn't get up to the Missouri Supreme Court, but there was a constitutional convention that came around in the early 1940s. And at this constitutional convention, some people from the western half of the state said, really, let's make sure that this is not a problem. We like the idea of being able to take these properties and then convert them to uses that we think are proper. And so they passed Article 6, Section 21 into the Missouri Constitution. And that provision allows you to condemn property, to use the power of eminent domain, if a local government or a governmental agency determines that the property is blighted. The constitutional amendment did not define blight. Now, at the time, people understood blight means you got property falling down, it's hazardous, there's a health threat to the community as a result of it. That was the understanding of what blight is. But because they failed to define it in the Constitution, as time went by, cities began to get creative with the way that they defined blight. And so you would have blight declarations coming down the pike because there's grass growing through your sidewalk, or because a building had outlived its purpose and become obsolete. The owner may think it's perfectly well suited to the use that they have for it, but if the city decides that this building is obsolete, then all of a sudden you can call it blighted. And so the condemnation wheel started to roll. And when Missouri courts took a look at it, even though you've got this constitutional provision that's saying if you're trying to condemn for a public use, the courts get to decide whether it's truly a public use, the blight provision didn't say anything like that. And so what the courts did was they said, well, since this is not a public use question, since it's a blight question, we'll defer to the legislatures. And that's essentially a rubber stamp. Or at least it was. Now, I will say that there has been a very tiny glimmer of hope in the landscape in Missouri on the eminent domain front. A couple of years ago, the city of Clayton, which, as we all know, is a downtrodden and blighted area, decided that they were going to condemn an office building that was perfectly serviceable, that was perfectly well maintained, so that the Centene Corporation could build a new headquarters. And the way that they did this was they said, well, we think it's blighted. That case went all the way to the Missouri Supreme Court, and for the first time that I have been able to find, the Missouri Supreme Court said, no, city, you're incorrect. This is not really blighted. Now the question that we've got is how far-reaching the Centene case is going to be. The way that the Missouri Supreme Court got to that solution was almost on a technicality. The statute that the city of Clayton cited when they were making their blight designation required two separate findings, that it was an economic liability and a health liability. Basically the city, when it was making its declaration, it only checked one of the boxes. So theoretically, if Clayton had gone back and conducted a second study that checked both boxes, the case may well have come out differently. But thankfully, the city of Clayton recognized that it was beaten. They let go the idea of condemning the property, and lo and behold, a year and a half later, they reached a resolution where the property was sold, and now Centene is building their building without the use of eminent domain, which all along, free market advocates have been saying can be done. Really, the question in terms of developing these areas, and I know that in St. Louis as well as in other parts of the state, there's been a lot of talk about how eminent domain is thought to be a necessary tool for development, and that's just not the case at all. We can point back to how development was done for centuries now in the United States without using eminent domain for it. different cities in the country have taken a hardline stance against the use of eminent domain. The city of Anaheim in California refused to use eminent domain so that developers could help build their projects. And the city's developed fine. Disney World was built without the use of eminent domain. Florida just recently went back and they amended their constitution after the Kelo decision to make sure that Kelo couldn't happen in their state. And development has continued at the same level as everywhere else, even after they said you can no longer use eminent domain to accomplish these developments. So, you know, we now have this section in the Missouri Constitution that has been twisted from its original purpose. And where it was originally intended to try and prevent harms to the health or safety of the community, you know, they've used it instead as a backdoor to condemn for economic development. So the position that we take at the Show Me Institute is that not only is this unnecessary for development, but it's actively harmful to the community. When you have the ability to condemn what belongs to one person just to give it to somebody else, it decreases everyone's confidence in their ability to hold their property. It makes them less likely to improve their property. It reduces the value of their property. The National Association of Realtors has written briefs in several of the eminent domain cases that I've worked on that have pointed out how property values tend to diminish when there's a threat of eminent domain, even when it's just a question of a surety that the city has that authority, as opposed to being assured of strong property rights, strong protections for property rights. And so for all of those reasons, really what Missouri needs to consider doing is adopting a constitutional amendment that would fix this blight exception that was written in the 40s. Last year there was an effort to do this. There's a group called Missouri Citizens for Property Rights, which is headed up by Ron Calzone. And they tried to get a ballot initiative going that would have amended the Constitution to fix this problem. And unfortunately, the developers and the League of Municipalities, using taxpayer dollars, mind you, filed a lawsuit that that prevented Missouri Citizens for Property Rights from getting that issue on the ballot. I will add that part of the reason that it was not on the ballot was the Secretary of State determined that they had not collected enough signatures. Now, the question of whether they actually had gotten enough signatures was in dispute, but the lawsuit brought by opponents of Missouri Citizens for Property Rights resulted in their not being able to contest that. But hopefully in the future you'll see another ballot initiative that will give Missouri citizens the opportunity to fix this problem and end the threat of eminent domain for private gain in the state of Missouri. I'm happy to take questions if anyone has got them.
Questions, anybody?
They've got three.
Herman?
Ron put three in it this time.
What was that?
Ron Calzone has three petitions in their in the early stages, you know.
Yeah, most
approved
CPR,
by the Secretary of State for signature.
Most CPR is dedicated to making sure that this issue gets up the next available opportunity. And part of the way he's done that is to draft several different versions of it, so that hopefully one of those versions will meet with less opposition, and then they can take it out, get the necessary signatures, and get it on the ballot. But yeah, we're very hopeful that Missouri citizens will have the chance to vote on this in the future.
Any other questions?
Yeah. Is there any movement to clarify or fully define what is a public use in Missouri?
Well, I mean, it's kind of irrelevant. I mean, Missouri did pass a statute in response to Kelo, and it was billed at the time by representatives of the legislature and the governor's office as being the fix to the problem of eminent domain. It was not, and they were told it was not. My wife and I both worked for the Institute for Justice at the time. IJ litigated the Kelo case as well as a number of other eminent domain cases across the country. And my wife's job was to advise state governments as to how to fix the kilo problem in their state. And she told the folks in Missouri that what they were proposing would not get it done. But they passed what they passed. And it did take some steps in the right direction. They did say that you couldn't declare farmland blighted. So that's a step in the right direction, and it's great for farmers, but it doesn't help anyone else in the state. They also passed a provision within that bill that said that in order to declare an area blighted, a preponderance of the properties had to be shown to be blighted. The Western District Court of Appeals in Missouri has already gutted that provision, and they said basically when the legislature said you have to show a preponderance of the properties to be blighted, it just means you have to take a really good hard look at it. And so, what reform had been accomplished doesn't appear to be going much. Doesn't appear to be providing much protection to people. As far as the public use question is concerned, like I said, Missouri's already got a constitutional provision that specifically says you can't condemn for private use, and if you try and claim public use, the courts are responsible for seeing if that's really the case. It would not hurt to go back and adjust the language in the Constitution a little bit to make it a little bit stronger. But really the biggest problem Missouri is dealing with is the blight question. If we can deal with the blight question, then it should resolve much of the eminent domain problem in the state.